From the Library of Congress in Washington, D.C.
Okay, I think we're going to get started with our afternoon session. We might need to open the door at some point. If it gets too hot in here, let me know. As I said, we apologize. We weren't able to keep the other room, which was much better accommodations. But hopefully we will continue the conversation that we started earlier. Our focus for the afternoon session, as mentioned, is on mass digitization. I will read our standard disclaimer with respect to audience participation in a moment. But in terms of one other kind of piece of logistics, I just want to reiterate to the panelists and to the audience that this is a safe zone. That is, we really would like to engage in I think, a very productive conversation. We obviously understand that this is a very complex and passionate issue in a number of positions on both sides, but we want to make sure that the conversation and back and forth is civil. No one will be serving process during this particular panel, hopefully, or threatening lawsuits, and we do want to make sure that the conversation is civil. That being said, I do actually think it is helpful to hear from both sides in terms of their beliefs as to whether best practices are things that they agree with or not, but we will just make sure that we do so in a very civil and productive manner. So our session right now is entitled Extended Collective Licensing and Mass Digitization. Our previous panel right before the break was focused on mass digitization generally, trying to come up with a definition of mass digitization that I don't know that we did, but we started the conversation. And now we want to really focus on potential solutions to that gray area that people were referencing during the last session. That is the gray area between something that folks may disagree on is fair use and something that is clearly infringing and should be exposed to statutory damages. So should there be some type of, for example, extended collective licensing solution that would be able to facilitate in a productive way, in an efficient licensing way, that licensing of the gray area? And that's one thing that we want to focus on today. We know, as I mentioned before, that extended collective licensing is something that has actually existed for some time in Nordic countries. Other countries, such as the United Kingdom, are also considering it very, very seriously, or in fact have adopted it for purposes of some issues recently. So we wanted to really explore whether, even though this is not something that we have currently in the structure of our law, is something that the United States should consider. Again, I mentioned earlier that the Google Books settlement, many believed was a form of extended collective licensing in some way, although it was done through a private settlement agreement as opposed to a government sanctioned kind of legal framework. And so we at least know that, at least for some users and content owners, that type of approach is not going to be completely anathema because they were willing to do it through the course of a settlement agreement. So I'll open it up first to kind of a general question. Is extended collective licensing generally something that we should explore as a possible solution for that gray area to facilitate the mass digitization and perhaps making available in certain uses in the United States? Oh, I'm sorry, yes. Before we do that, I'll go around the table. I'll start with Fred from the NFB.
My name is Fred Schroeder. I'm with the National Federation of the Blind.
Jan Constantine with the Authors Guild.
Ben Sheffner, Vice President, Legal Affairs, Motion Picture Association of America.
Lauri Rechardt, IFPI, which is the association representing the recording industry worldwide.
Jim Mahoney from, notably, the American Association of Independent Music, which is small and medium-sized independent labels in the U.S.
I'm Colin Rushing. I'm the General Counsel of Sound Exchange.
Cynthia Turner, co-chair, American Society of Illustrators Partnership.
Hi, I'm Greg Barnes. I'm General Counsel of Digital Media Association.
I'm Ariel Katz from Faculty of Law, University of Toronto.
Michael Weinberg, Public Knowledge.
Debra LaKind, Museum of Fine Arts, Boston.
Michael Furlough, I'm the incoming executive director for Hathi Trust.
Brandon Butler, I'm at the American University Washington College of Law.
Corynne McSherry, Electronic Frontier Foundation.
Erik Rydén, National Library of Sweden Senior Legal Advisor.
All right, thank you, and I think you know all of us. Oh, actually, one more.
Yeah, I'm over here on the government side for some reason. Casey Ray from Future of Music Coalition.
All right, thank you. Again, I would open it up with just a very general, broad question. Is ECL something that we should consider in the United States to foster licensing in that gray area for purposes of mass digitization? Starting with the Ariel.
Okay, so the short answer is no. Okay, and now the reasons. Okay, the reason is that the American copyright system has a deeply rooted market logic to it. Okay, while it is based on the grant of limited exclusive rights or mini monopolies, it also contemplates competitive marketplace between copyright owners. And this has actually been a defining feature of American or Anglo-American copyright law since its very early beginning. It was a feature that was designed by choice, as this idea of competitive marketplace was designed as an antidote to the oppressive monopoly of the stationer's company that Parliament has revolted against at the beginning of the 18th century. And the idea of marketplace of competing copyright owners is also intimately and historically connected to the notion of the marketplace of ideas that underlies the First Amendment. And consistent with that, the United States has, among most nations, has the most minimalist system of collective administration of copyright. And when they exist, they are closely supervised under antitrust laws, for the most part. And the justification for that, and when those collective administration organizations exist, at least the assumption is that they are efficient solution to a market failure. Okay, and therefore they enhance efficiency, and they're also no more anti-competitive than is necessarily the case to solve some clearly identified market failures. Now, within this framework, before we adopt extended collective licensing, we therefore should ask what exactly is the market failure that we're trying to solve here? Can ECL actually solve the market failure or merely shift it away? Can it solve it without creating other problems or even bigger problems or just as important problems? And how ECL actually compares to other solutions. And I think ECL does not really solve the problem, right? The fact that you pay someone for the use of works of unlocatable copyright owners doesn't solve the problem that those owners are allocatable. So it's easy to collect. ECL is a very easy collecting mechanism, but there's the question of how you distribute the money, to whom you distribute the money. That's one set of questions. The other is, again, if we get rid of the mechanism of competition, then you have to get into the question of, okay, how do you set the rates? Now, that's a serious issue for the music industry, but music is relatively a simple thing compared to what we're talking here, because, again, most kind of popular music is radio stations that play the entire song. It's probably not fair use. And the products are quite homogeneous, right? I don't know, 3-minute songs, right? Here we're talking with an enormous array of works, okay, from letters to, you name it, we all know what it is, that many of them don't actually have any market to use any benchmark to determine the price. So it's a total unknown. So again, it's a very effective mechanism for collecting. You create a monopoly that collects money. Some users may be happy to do that because they get a license and they're fine. But that's not that much different. I mean, if the problem with orphan work is that people don't pay, okay, that solves the problem. But I don't think that's the problem. It's not a sin to use work, right? And in a way, ECL is not that much different, in my view, than what the Catholic Church did in the late Middle Ages when it started selling indulgences. So people could pay They would get a license to monetize. There was a very effective way to monetize sin.
Okay. All right. Well, thank you very much. I don't have to hear. We've heard about, we've had Plessy versus Ferguson, and we'll have the Catholic Church. We'll try to focus it in on specific things happening in this century. But let's try Jim. I think Mahoney was next.
I'll try and help here a bit, because representing small and medium-sized independent labels, my community would be slightly bruised that you think that music is all played on the radio or has no value, because my membership includes labels that invest in blues music and classical, and the list goes on and on. But nonetheless, but I do agree that music in particular has spent the last 15 years losing a ton of our value to work towards maturing a marketplace of licensing and working on rates. And so while I applaud and am appreciative of being invited to this, I think that for music in particular, to the purposes of what you smart folks might talk about today, extended collective licensing wouldn't be a solution. In speaking with my members prior to coming down here, I noted the European models, and even with the opt-out clause, they say that the price is forced downward for even those who choose to opt out because of the immense pressure, in particular, on the smallest of players in our community.
All right, and I think I have Brandon Butler, and then Lauri, and then Fred.
Thanks, and Jim's remarks sort of anticipate mine very well. So I want to sort of say two things. One is sort of in the real world, so this is based on a little article that I did, sort of collecting anecdotes about collecting societies. What are people saying about them? How are people affected? And Jim raised the great point that smaller entities often feel that collecting societies are not attentive to their needs, right? They get lost in the mix, and all of the attention goes to the stars. Meanwhile, larger artists complain, so I'm just going to go through very quickly some of the complaints we found. Larger artists complain that the revenue from their works are being used to pay for the collection of royalties for the small guys, right? Because some of those royalties aren't even worth collecting in the view of the larger guys, and you're taking some of my money and using it to get that guy's money. All of the authors who use these societies, even the ones who choose to, have complained about inefficiency, non-transparency, right? We don't know where the money goes, where it comes from. Corruption, I mean, folks who run these agencies have been indicted in some countries. Lack of accountability, mismanagement, high overhead, slow pace of adaptation to new market environments. This last one is especially of great concern to smaller artists, right? There are all kinds of ways to make your stuff available, and large centralized licensing folks sometimes aren't keen to allow those new uses in favor of old uses that favor larger, more established artists. Users, on the other hand, also have complaints about collecting societies. So, for example, sometimes users are bullied by overreaching licensors, right? Once you tell someone you can collect money when someone does X, the definition of X gets larger and larger in their view, right? And so users sometimes feel that, gosh, I'm just running a mom and pop store. The kids are, the Girl Scouts are trying to sing fire camp songs, and we get a demand letter. Users can be galled when they see that the license money that they give to licensing organizations are then turned around and used to sue more users, right? So I know in the library context, the fact that we give money to CCC and then they fund lawsuits against libraries just drives libraries bananas. And then finally, users, of course, are harmed when there is monopoly pricing, right? When there's one person who they have to go to for a license, then that price of that license is no longer subject to competitive influences. The other quick point I wanted to make was that ECLs can have a real damaging effect on fair use. So as Professor Carroll pointed out, I think by definition, any orphan works or mass digitization scheme needs to pick up where fair use leaves off. In reality, though, what we've seen is that risk-averse potential fair users love a safe harbor, right? And they can be taught to love a safe harbor as well by the folks who are outside of the safe harbor, telling them what happens if they leave. And so when you create something like an ECL regime, you're going to have people paying who don't have to pay. I mean, by definition, and that's a tax. It's an unnecessary tax on those socially beneficial uses. We've seen this over and over again. A savings clause, on the other hand, is both unnecessary and insufficient, right? So this is the last thing I'm going to say. It's unnecessary because fair use is a constitutional doctrine. We know from Golan and Eldred that fair use is a First Amendment right. And so if you don't like what judges have said about fair use, you're kind of in the same position as someone who doesn't like what judges have said about public fora, right? I mean, you're kind of stuck with it because it's a First Amendment doctrine. So it's unnecessary, but that kind of doesn't matter because if you, again, it will be an ineffective measure because, as we've seen in the lawsuits that are already afoot, we've heard that 108 doesn't allow for fair use, even though it's right there in the plain text. There's your savings clause. And similarly, you know, as I said before, once there is a perceived safe harbor, it kind of doesn't matter that you're told, in theory, you could leave. People don't leave. So there's a real risk there of fair use shrinking as the ECL grows.
Okay, I think I have a long list of people. I have some follow-up questions that I'll ask in a minute in terms of does the flip side also apply as well in terms of people who are risk averse maybe wanting to have a safe harbor through a legislative because they don't want to risk, you know, even, you know, the possibility of litigation. But I think we had Lauri next, then Fred, and then Mike Furlough, and then Mike Weinberg. Oh, okay.
Thanks. And actually, maybe in a way, just to sort of to complement what Jim was saying, and what I'm going to say is from the point of view of the recording industry as a whole, both the big one majors as well as the small guys. What I'm going to say is also probably from the international side, but looking from the outside. And if the question is, do you need ECL from the recording industry side? I think the answer is no. Licensing already works. But at the same time, again, you know, if you look at the different models that are applied, yes, you know, the first option, if you will, is always to go direct, license directly, and that's what the industry is doing. But having said that, in many cases, in the U.S., outside the U.S. even more so, the industry is also using collective licensing as a tool, but it's always voluntary, if we can choose. Voluntary collective licensing when collective licensing makes sense. And the problem with ECL that we see around the world is basically that it forces people to use collective management organizations even if they wouldn't want to do that. And I don't think that has anywhere proven to be the best solution to the real or perceived problems with rights licensing. And the last point is there's a little bit of sort of collecting society or CMO bashing here. Some of it, I'm sure, you know, is at least partly justified. But part of my job is to oversee the recording industry collective management organizations, so music licensing companies, actually, as we happen to call them, globally. And I can assure you that these guys, in the main, they are good actors, they're responsive, and what they want to be, or at least, or at the very least, become, is sort of responsible service organizations that whenever the industry needs collective licensing solutions, they are there and they can provide those services. But it's all based on voluntary, not statutory solutions.
Okay, thank you. And we'll go to Fred next, then Mike Furlough, Mike Weinberg, Casey Ray, and Jan Constantine.
Thank you. Let me just begin by saying that mass digitization creates an opportunity for blind people to have access to information in ways that are unprecedented. Think about it, blind people have literally not had a means of reading and writing for, it's been less than 200 years since Louis Braille developed a Braille code. And with mass digitization, this gives us the opportunity to gain access to millions of works that otherwise would have been unavailable to blind people. I know you all know this, but I set that stage to say that anything that inhibits or has a chilling effect on activities of mass digitization will serve to limit access not only to the broader community, but specifically to the blind community that need these works. particularly in the area of academic study. And I won't belabor that point. So I'm not a copyright expert and not an expert on intellectual property, but extended collective licensing, if it has the effect of reducing the efforts of mass digitization, that will have a serious impact on blind people and our access to information. Not to be maudlin about it, but blind people wanting to read isn't just to sort of pass our lonely hours. Blind people want to be active, productive, employed, integrated members of society, and access to information is key to that. Second thing I would say is I understand the need to protect intellectual property, but once materials have been digitized, whatever structures are put in place that allow access to that material, those procedures must not be so cumbersome, again, as to inhibit access by the end user. In other words, they should be simple enough, straightforward enough that blind people and others who are using these works can readily use them and use them with certainly whatever safeguards are needed, but still remembering the needs of the end user. Last thing I would say is, again, with materials that are made available in digital formats to blind people, I know there's concern that what if some of these materials then make their way into the marketplace and all of that. And I certainly understand that concern. Blind people aren't in any way seeking to damage the intellectual property rights of authors. But at the same time, there's a pretty long history of materials being produced in alternative formats. And as far as I'm aware, there literally are no data, no instances of those materials, be they put in Braille, be they recorded, etc., that have been misused.
Thank you. We'll go to Mike Furlough, and then Michael Weinberg, Casey Ray, Jan Constantine, Yurker, Ben, and Corynne.
I'm Mike Furlough. I'm the Executive Director for Hathi Trust, and I wanted to say how proud we are to be working with the National Federation of the Blind to be able to make so many texts accessible to readers who are print disabled and sight disabled. So I guess the point I want to make here is that we've been talking about ECL as a solution to mass digitization, and I'm not sure that mass digitization, as we've conducted it with Hathi as a solution, needs a solution. We've shown that we're able to do this within the boundaries of the law. We make lawful uses for search, we make lawful uses for preservation, and we make lawful uses for access to the blind. To extend a collective licensing regime to something like this would make it fairly impractical. Mr. Desai from the Library of Congress this morning spoke about the costs that are invested in making mass digitization efforts or any digitization efforts. To add further costs on cultural heritage institutions begins to add a tax on what we do. And I would remind everyone that cultural heritage institutions exist to serve the public. They exist to serve the folks in this room, not just their own needs and their own ends. I think the last point I would make at this point is to build on something Brandon was saying earlier, and that is, if collective licensing regimes will take off where fair use leaves off, there's a real concern I have in making it the norm to pay. I think this is, as Brandon was saying, if it becomes the norm to pay, then individuals become less willing to take risks or more risk averse. You at that time then begin to see the fair use bar pushed farther and farther back.
Yeah, and I was going to follow up, but you kind of answered the question that I was going to pose, but others might as well, in terms of, yes, there are certainly, issues already kind of decided, at least on the district court level, as I'm sure we would be reminded, with respect to what mass digitization would be allowed under fair use. One of the main issues that wasn't addressed in the Hathi Trust or the Global Books case was full access, beyond access for persons who are blind or otherwise print disabled. Yeah.
I just wanted to point out, yes, that's the case. We do not make full text access available for in copyright works. Never have.
Yeah.
There are mechanisms that exist for us to do so by working directly with rights holders, however. And we have worked with many rights holders, individuals, and publishers to make their materials openly available through Hathi Trust with their permission, where they hold the rights to do so. So there are mechanisms that work now to do this.
Michael Weinberg?
Yeah, and part I just wanted to echo again this concern that I think I'm encouraged that I've heard a lot of concern about the idea of formalizing some sort of extended collective licensing for all these things under mass digitalization for all the reasons that have been said before. I also want to, just because I know this is the Orphan Works and Mass Digitization Roundtable, and I also am glad that we largely separated those two issues, but because it is that, I wanted to just put a flag and say that extending this idea to some sort of way to address the Orphan Works problem is one that would raise a lot of concerns, not the least of which is almost by definition, you're talking about the kinds of works that Brandon were talking about, the users who are at the very far end of that tail, and you run this risk that always exists with collective licensing, but especially in an Orphan Works context, of generating a large amount of money that is not really dispersible or dispersed to anyone, and so creates a drag on the economy. And so I'm glad that we're actually not talking about that, but I wanted to at least mention it.
Casey?
Thanks. In some ways, ECL feels a little bit cart before the horse, because in order to have truly functional and effective collective licensing mechanisms, you probably need interoperable and standardized database systems. Obviously, that doesn't exist in the case of Orphan Works, but we could think not just about right now, but think about the future. Everybody's talking about, for example, Bitcoin as a currency, but the blockchain technology could be used just as easily to track rights ownership. And, part of the problem with Orphan Works is figuring out how to deal with it now. ECLs should be part of the conversation, but we should also be looking in the future to mechanisms that can be devised that would limit the number of new orphaned works. Smarter database systems, better tracking of ownership could aid in everything from knowing who to pay to also being able to send the notice to the right person in an instance of one wanting to exercise their termination rights. In defense of today's, existing collecting societies, we have to remember that the systems that we're dealing with now were largely devised to operate in an analog world, with the exception of Colin's organization. And clearly the use environment is much more diverse, and the systems for tracking uses can be much more granular. But there are virtues to the existing system, and one that doesn't get brought up enough is leverage for smaller artists who aren't able to compete or even get to the negotiation table in direct deals. And I think that, even if there are tensions in how rates are determined and set, it's important to remember that some of those artists really do depend on having a proxy in negotiations when rates and uses are being decided upon.
Thank you. We'll go to Jan, and I don't know if you want to discuss any of the positive aspects of the Google Book settlement, as I said, which was kind of a somewhat of a model that people thought was an ECL, but there were, obviously, antitrust and other kind of monopoly type concerns raised with the specific settlement.
Right. I would like to say that collective licensing presented us with a way of resolving the Google dispute, which all of the parties, as I said, including libraries as third-party beneficiaries, believed was a win-win-win. And just to briefly state, authors and publishers as right holders had control. They got compensated for uses. Their works were digitized by Google, and they had access to those works for those who wanted it, and out-of-print works had new markets for their books. These were non-exclusive rights that were given. They could take the rights for the digital books and do whatever they wanted with them. Libraries were able to have mass digitization of their collection, preserved copies. There was access for the visually impaired, and limited access for restricted uses as per the terms of the settlement. And Google had its business models. It got released from past infringements and made lawful future uses, and funded, I think $40 million was the funding for a registry that was going to take a very small administrative fee, only 5%, I believe, and it was going to use money to find rights holders so that the Orphan Works issue would be minimized. And Google also agreed, unlike Hathi Trust, to remove all works from the database and exclude works from business models if a creator wanted them to. Hathi Trust, I understand, Mike, and you can correct me if I'm wrong, takes the position that everything stays in the database because to take anything out would be to put a hole in the database. So nobody, if they wanted to talk to Hathi Trust about removing their books, they would not be able to do so. So it basically functioned as a de facto collecting licensing organization. It was a clearinghouse for rights, and its mandate was to pay rights holders, and I think it would have worked. The court would have blessed it, so there would have been a kind of court-driven due process of law, although the government wasn't involved. And there was a default-in mechanism for out-of-print books. The focus of it was to be on out-of-print books, and in-print books were not in unless somebody affirmatively asked them to be in. And I think the reason why that was done the way it was done is that all parties felt it was a good solution. Unfortunately, the Justice Department didn't agree, and there were others who were third parties who took issue, although many of them have come to me and said if they had known now what they knew now, they would have supported it. But in any case, that's behind us. I do believe that there are elements in there that could be useful. The Nordic models are efficient, and they've proven successful, so we could support something along those lines. We would insist on an opt-out right for an individual author to license individually because I think that's important. We would insist upon a representative body to negotiate licenses, and the authors would have to be at the table. There'd have to be an opt-out right if an author was unhappy, and it would have to be secondary rights limited to areas that make sense, like photocopying and library lending. And it would have to be an inexpensive and efficient dispute resolution mechanism like we had in the settlement agreement, which I think would have benefited everyone, and in the same way that the small claims court would. It would have been very easy to do and would have resolved a lot of disputes beforehand.
Thank you. And we'll turn to Yorka, which actually I think is a good segue because you mentioned the Nordic model and other foreign models in terms of VCL, and maybe you can give us some examples of some of the things that have gone on in Europe in terms of the development of VCL.
Thank you. First of all, I'd like to clarify just as far as fair use in ECL, we don't have fair use, but we have exceptions for digitizing for preservation reasons. So you don't need to use an ECL for that, and either to do text mining if you have an exception in your national legislation, as in Norway and soon in UK, and something might happen also in France. ECL has not been introduced on European level with the exception of the Satellite and Cable Directive, Article 9. It is a solution that exists in national states and member states. In 2010, although the EU Commission initiated a stakeholder dialogue on out of commerce works, a lot, and then it was narrowed down to books and learned journals. That took 8 months, and it is a soft law solution. The stakeholders, publisher, writers, all of them signed this MOU and agreed upon the principles how to digitize and make available. It was also in the interest of the publishers, but they also need a license, because going back, they have not the digital rights in Europe, so you also need that kind of solution. As to this day, this has been transformed into national legislation in Germany, which is the biggest publishing nation in Europe, past both chambers. And most likely the rest of Europe will follow, is already introduced in other countries. So that's the situation. It's a voluntary agreement. You give an example of the ECL provision in the legislation to extend license to non-members, including orphan works, which enables the national broadcaster, for example, to digitize the archive. They're a producer, but they don't have all the rights, and they are unclear of some rights, just like Google case. The agreement was not entered on behalf of the film industry. They choose to not be part of it. And that I stress, they choose not to be a part of it. That shows they were not in their interest, they were not part of the agreement, and they protected the interest. And that's okay. That's the way it should be. So that's the example of it's voluntary. As far as these extended effect on the outsiders, And the non-members, also include the Orphan works, the usage of ECL previously was an analog word. Of course, in the digital world, it will be quite different. It has to be widely publicized. You'll have to have databases you could search as you write solar, is my work part of this repertoire being digitized? So you have to have several safeguards, different to the old ECL solution, which was then reproduction at universities, photocopying more or less.
And one just follow up, in Germany it said that they're the largest publisher in Europe that, or publishing country in Europe that has ECL. What types of uses are you allowed to make?
Well, that's the driving force was still, as I mentioned before lunch, Europeana, but the Commission realized that the Orphan Works Directive would not do the job, and actually the stakeholders, all of them, approached the EU Commission, said, we want a market-driven solution. The stakeholders should sit down and discuss a solution. So this one was facilitated by the EU Commission, but the stakeholders agreed upon the terms and conditions, given the mandate they have. And then Germany is the biggest publishing nation. It's about then giving Europeana digitize and make available on the internet. As I said, it's a twofold interest. Also, the publishers have an interest in this, the commercial interest.
Thank you. Ben and then Corynne.
Thank you. I just want to go back and sort of echo something that Lauri mentioned at the beginning of this panel, which is that the preference should always be for individually negotiated licenses between copyright owners and those who wish to exercise any of the Section 106 rights. And I think the Copyright Office, in fact, has recognized this before. I was, in preparing for this, reading back through the 2011 report, and I just want to quote a couple sentences to this, which I heartily endorse. It says, a mandatory licensing scheme would be a measure of last resort. Congress would need to conclude that there is a compelling public need and that that need is frustrated by market failure. It would also need to be sufficiently narrow to comply with treaty obligations of the United States. I would also just add that it needs to be, that any such system, whether it's ECL or statutory or compulsory license, whatever the specifics, needs to address the specific market that we're talking about. And one thing that's become sort of been highlighted for me over the last couple of days, listening to the discussions, is, you know what archives do with 100-year-old letters is just a world of difference from what major motion picture studios do when they release a movie that they just spent $200 million producing. There's different problems and there's different solutions that would need to be devised to facilitate licensing. Frankly, from the industry that I represent, voluntary licensing works very well. Studios are able to negotiate with all sorts of distributors and arrive at market prices that tend to work pretty well. There's now over 100 different legal websites to watch movies and television for consumers, not to mention all the traditional licensing arrangements with movie theaters and cable channels and networks, and then new models like Netflix and Hulu and all of those. So when we're talking about things like ECL, again, it's not that ECL is good or bad, or that any sort of collective licensing scheme is good or bad. When I was walking in here this morning, I noticed the banner celebrating 100 years of ASCAP. That's a collective licensing system that has survived the test of time, an entire century, and I think it's nothing is perfect, but it's worked pretty well for both songwriters and publishers and those who wish to license it. But again, there's no one-size-fits-all for any sort of these licensing solutions. You need to look at the specific technologies and market conditions and economics of each individual copyright sector.
Thank you. Corynne, and then Ariel, and Yerker, and then Debra.
Okay, this doesn't actually happen all that often, but I mostly... That's like one other time ever. And along those lines, I'm going to keep my comments brief so that we're not being too repetitive. I think that it's right, and I think I'm hearing this from a number of different sources, that what is likely is that there's not one solution, right? And depending on the kind of work you're talking about, different solutions might be appropriate. I mean, even within just books, there's many different kinds of authors. I talked to a lot of academic authors, and they didn't like the Google Books settlement because they didn't feel like their their interests were being represented, or they right to be read. They don't need to be compensated. They don't care about that, and they were worried about that. So depending on even the kind of author you are, you have different interests. And I hear a lot about maybe voluntary licensing systems, which I think make a ton of sense, or at least fit the situation potentially a little bit better. And also, it's not just the different kinds of authors and different kinds of works, but also varying status of the work, right? Is it a 100-year-old letter, or is it a $200 million motion picture that came out last year? I do think that's an important distinction to make. Is it in a copyright or out of copyright? So to the extent that we talk about these things, I really think our first impulse should be trying to narrow down what problem do we really need to solve right now and focus there, rather than trying to come up with global solutions to all things, which I think will take a lot of time. The one thing that I haven't heard, and I don't think you're likely to hear from anybody else, is I work for an organization that cares very deeply about intellectual property rights. We also care very deeply about privacy rights. And so the one thing I just want to put a pin in is that as we continue these conversations, one of the after effects of licensing schemes, depending on how they develop, is you could start collecting a large database of information of who's reading what, who's listening to what, in what circumstances. And so I just want to put on the table, we're a long way away from this, but privacy concerns have to be on the part of that conversation should we ever get there, because that's a lot of First Amendment protected information.
Thank you. Ariel?
Okay, I just want to kind of to make a provocative thought experiment. Okay, there's something about extending collective licensing that sounds great, right? It's extended and it's collective and it's licensing.
And it's licensing.
And it's European and okay, so I have a proposal for a startup idea. Okay, I want to recruit a few authors. I'm an author, and there are a few authors around the table. And we create a licensing scheme for the use of our works, and we sell licenses. No issue with that. We are totally entitled to do that. But we also say, okay, but we have a business model. We tell our users, you pay us a fee, a subscription fee, or whatever model we use, and we actually give you a license to use not only our works, but the works of anyone else, even if they have never authorized us to act on their behalf. And we're good and reasonable people, right? And we collect the money, and we agree, and we promise to pay any non-member. If you show up, we will distribute the money to you. And we even will try to locate you, even if you don't show up. We put the money in escrow, and we just collect on behalf of everyone. I don't think that's legal, right? I think Napster eventually they wanted to do something like that. They said, we'll start a business, and then we figure out with the copyright owner some workable model. And they were the courts frowned upon them, and maybe rightly so. So what's the difference? Is the fact that the organization is owned by copyright owners that have some authors on the board? Does that really make a difference?
I think it would have to be legislation. Probably would make a difference. That would legalize it, but others might have a different opinion.
Why with something we frown upon in one context, and then we think, okay, we may need legislated, but what's the point of letting one person administer the rights of another?
Yeah, and I think that's one of the things that we might actually explore even more in detail in the next panel. But if it was legislative, you would have the opportunity to provide certain standards and requirements for any collective management organization. You would have ongoing oversight by the government. So there are things that would mitigate any concerns that you would obviously have if some just, pirate wanted to go in and try to operate as a collective management organization. I think, Yoko, you were next. And I don't know if you have anything to offer in terms of the actual experience practically in some of these countries that, have ECL. Are there any statistics or data that you would suggest that we look at in terms of the effectiveness of ECL regimes? And do you know anything, not to put you on the spot, but I think one of our only, other than Ariel, foreign expert on this, on the panel, but do you have any experience or evidence in terms of how things are going on in the United Kingdom, where they just, did adopt an ECL? I don't know. It hasn't actually kind of been put up yet, so to speak, but I know that that was something that they recently discussed and adopted.
Please remind me if I forget any of the questions.
Yes, sorry.
Ben Sheffner really stressed two very important issues. I think you stressed two. One was that the traditional way to licensing is the number one, and also stressed in the ECL legislation in Sweden. If you could read Swedish, you would know that, but that's the problem. But it's stressed that's option number one, and collective licensing is something you consider if the transactions cost are so high it's simply impossible, and then you have the problems with the
market failure.
In market failure, simply. But that's stressed in the legislation. As far as competition in Sweden, you can have competing collecting societies. But it's like Google's market penetration in Sweden is over 90%, small country. These are per se monopolies because as an author I have a monopoly. So it's kind of difficult to have competition, but you can actually have it. The legislation is open for it. It's for the market to, well, find a way to be competitive. As far as your questions, as UK, I had just had a chat with a colleague at IPO, and she said they have all the formal decisions, so it's more or less a formality now to introduce it. And then experience.
Yeah, just general, is there any kind of like hard data or, in terms of
as far
experience?
as, I think actually the CEO of the Swedish RO, he had been here for a RO conference, IFRO. He had a presentation, he could provide figures of actually how quite effective the Nordic ROs are, because they're quite effective to deliver revenue to the rights holders. Mm-hmm. It's an extremely lean organization who do not have, that's their side of it, to have any kind of bureaucracy imposed by the European Commission as far as regulations, because there will be additional overhead. So you're happy to contact IFRO, and they could then forward information. As far as usage, what libraries would need, as we see it, as making available internet, is a streamlined as far as the library and cost-effective, low overhead, and the rights holders' positions would be to protect the rights. That's not a problem. That's rather helpful, because we don't want to be caught in a situation where there would be some kind of ambiguity as far as we are violating copyright. So the CMO, RO, is a safeguard to that, and take on that role to safeguard us, rather than being in some kind of uncertain situation. That's the library perspective. Thank you.
Thank you, and I was going to just follow up, and we can maybe get back to this at some later point, but I know that there are some people waiting to speak, but I know, for example, in Finland, with the ECL model, they have a role where the Ministry of Education actually, approves the CMO in some sense that will be using the ECL, so those are some of the types of models that they do in other countries to ensure that some of the concerns that have been raised about transparency, corruption, and things like that, are not actually part of a CMO that exists in the United States or elsewhere. I think we had Debra and then Brandon. And then
I just want to reiterate from a museum perspective that individually negotiated licenses work for us. That's really the best way. That's what we've been doing. We're not only content providers, but we also use other people's content as well. So it's kind of a license that works both ways. So we kind of also have a dual mission, this whole idea of access to the collection. We want to obviously try and digitize, not necessarily everything in our collection, but the objects and works that make sense. We have, 100,000 shards of Egyptian artifacts, and quite frankly, they all look the same. So you really don't need a photograph, a high-res image of that. However, our works on paper and our European and American paintings and such. But we rely on revenue from licensing, and we negotiate those deals. And you've probably heard now in the museum community, there's this whole trend now towards open access and open content, and how the Smithsonian has put 45,000 images online for any use, not just educational use, but commercial use as well. And we're seeing that that is seriously affecting, it's affecting all revenue stream from generating revenue from licensing. We are all for, free and open access to scholarly and educational use. However, the MFA, we rely on income that's generated from licensing or collection. You've also seen, I believe it's the Getty now has always had that policy. Well, these are institutions with large endowments and that are funded by the government. We are a completely private institution, so we rely on that revenue from licensing. And I think any type of collective, association would not be in the best interests of a museum.
Thank you. Brandon and then Cynthia.
So I want to see if I can describe very briefly what I think is a kind of consensus here. Cass Sunstein calls this an incompletely theorized agreement, right? John Rawls calls it the overlapping consensus. It's a shallow agreement. So I think commercial rights holders, the folks in this room who own rights, whether they're writers or publishers or whatever, and then the downstream users, whether they're librarians or website operators or whatever, they all agree on a couple of things that I think are really important. Where there's a ready market solution for your non-transformative use, right? It's just, you're just doing you're in the market, you're competing with Best Buy, you probably ought to get a license, right? And any legit person is not going to be able to look you in the face and deny that. And then where there is fair use, whether you're talking about commentary or whatever, pick your core fair use, whatever that is, maybe preserving, rotting films, right? That's in the history of the Copyright Act. The Congress said, surely if anything is fair use, preserving films that are rotting in warehouses, that's fair use. Even if there's a lot of them, by the way. So there's this incompletely theorized, so when it's fair use, don't pay. When it's not fair use, pay. And everyone in this room believes strongly, rightly, that they are not an orphan. They know where they live. There were submissions in one of the last inquiries along this lines, somebody thought my dad, who's an author, was an orphan, but he's not because I know where he lives, right? So no one in this room thinks they're an orphan, and the folks who are in this room who are rights holders are definitely afraid of being wrongly classified that way. And so for any use, either no exception or limitation applies, and in that case, everyone agrees a negotiated agreement is the right thing to do, right? Where there's no limitation or exception already in the law, what you want is to talk to the other guy and come to terms. And also everyone agrees that where there is one that clearly applies, you shouldn't have to do that. What we disagree about is the line, right? What divides those two situations? And I think that line's going to get clearer and clearer. It's getting clearer, and there might be some more lawsuits and some more case law in the coming years. And so I think there's no one who thinks we should create, or very few people so far, I think, who think that those two categories are not exclusive and that we should create a third category for things that are neither fair nor subject to this free market thing. And they're all very, very worried about what happens when you do that. And I just wanted to see if that's a description of what's going on.
Well, I will just say that, just to let everyone know, obviously we have a certain number of people, 16 people here who are participants. We've gotten a lot of comments, so there are different perspectives raised, and some supporting, some not supporting ECL and other approaches in the written comments, and we're going to ask for more submissions. So I don't know that we can say that there's a consensus just based on the participants here. And I will say that there was, in the last panel and a little bit here, a discussion of this gray area in between and whether there should be some type of solution that is not necessarily, again, fair use or infringement, perhaps not, extended collective licensing, perhaps voluntary collective licensing or something else, but there was a discussion of what should we do about that gray area. I think I have Cynthia next, and then Casey, and then Fred, and then Lauri.
I'd like to speak about visual art and specifically about illustrators for a little bit, because visual art does have to have some special considerations, and I think it warrants special exemptions here in the Orphan Works and the mass digitization schemes that are being talked about. In past Orphan Works legislation, visual art was swept in, all visual art, as orphans, even by living creators currently licensing their work. And we risk that again in any of these schemes that have been talked about today. From 2005, we have very openly advocated for very limited defined exceptions to allow archivists, museums, and libraries to complete their missions. Any orphan works legislation has got to be sure that it does not invade functioning markets. Copyright exists to create the property right to sustain a market for us to disseminate our works. Now, when we move to mass digitization, which to me is a completely separate entity than orphan works, and it bothers me that we have to talk about them at the same time because I don't see a lot of overlap. So I'd like to address that separately. In mass digitization, speaking again for illustrators, for visual artists, our work is at risk in two ways. Most visual art is contained. It's both standalone, so we risk having mass digitization of individual works. But it also is embedded in books and periodicals, which are being swept along. Now, it's very nice that people are working on negotiations with publishers in some cases. But we have a 30-year history in this country where visual artists and writers have not been permitted to participate in the reprographic licensing of the secondary rights streams, even with Supreme Court wins with Ticini. And it's been mentioned by Barbara Ringer, it's been mentioned by Ruth Bader Ginsburg, that there's an extreme need in the U.S. to create a functioning reprographic licensing system that will address this, and I see that as a solution. It's not an extended collective license by any means. I see that as a good potential solution for mass digitization.
Thank you. I think we have Casey and then Fred.
I think Ben was really smart to bring up the distinction between different sectors and different practitioners and different expressive works and how they relate to the marketplace and what might or might not work in a collective environment. I would also say, though, that I don't want to speak for Jim, but I know that some of your members must understand pretty acutely what it's like to have perceived market share work against you in voluntary licensing scenarios. This is a really great conversation. I'm having a little bit of difficulty personally. It might be the cold meds in separating the part of the collective licensing conversation that applies to orphan work solutions and just the generic idea of collective licensing mechanisms, blanket licenses, compulsories or consent decree managed licenses, and their efficacy in, like, Ben would say, very specific use environments.
Fred, and then I actually have another question for the group.
Yeah, on this issue of the extended collective licensing, I'm thinking for the museums, I'd be glad to give you a license for those 100,000 shards of Egyptian pottery, and I promise I'll go try to find the pharaohs to whom those shards and pay them their royalty. Where I'm going with this, one of the concepts, and again, I mentioned sort of the economic disincentive to digitize if there's added cost and the impact that has on access to materials for blind people. But also the very idea that a library that has purchased a book and digitizes it and is not making full text available has really changed the nature of the book in such a way that it has to seek permission from rights holders, or alternatively that a right holder could say, I want you to take that out of your collection. Again, really works against the public interest of access to blind people. And I say that because a sighted person, assuming a book is in print, can go and buy a copy of the book, or if it's in a library collection, they can go and read it. That's not the case for blind people. And if there is a digitization of a work that now makes it available, but the right holder, for reasons wholly unrelated to access to blind people, whatever reason says, I want this book taken out of your digitized collection, we again are left with no access to that book, even though all of the work to make that book accessible has been done. So again, my point here is simply to say, as you look at these very technical and complex issues, we urge you to bear in mind that there is a sector of the population that desperately needs access to these works and consider whatever scheme is put into place that it not have any chilling impact on access to blind people.
Thank you. And so I actually do have another question, follow-up question. I want to kind of narrow our focus a little bit in the final few minutes before we open it up to audience participation, because I did take notice of a lot of the comments which said that you can't have a one-size-fits-all solution, and that it has to somehow take account of the work, take account of the use. So just narrowing it down to maybe books, because I think we have a model somewhat already in the Google Books settlement. But what do people think in terms of an approach? As I said, where we know there is a gray area with respect to the law in terms of full access. The Google Books settlement would have provided access in certain circumstances, at least in libraries, through a subscription model. Would that be something that people would think is something that should be supported and maybe done through some type of legislative or ECL model? Is that kind of narrow focus something that people would be willing to consider in light of the fact, obviously, that certain sectors were willing to consider it at the time of the Google Books settlement? So I just wanted to throw that out there, starting really narrowly just on books and access to books through some type of licensing or ECL regime. Yes, Mike.
No. No, I think for the reasons I stated earlier, that I think we're looking at adding costs into access. And it's not that we don't want to pay for legitimate uses, because we do, and we can, and we have. But I think that adding costs into the system for access to works we already have on our shelves, it's a little difficult for us to swallow. We do it sometimes with certain publishers, but we try to avoid doing it, and to do it across the scheme of all we have in 90 libraries would be quite challenging.
Now, I have one quick follow-up on that, in the sense that if the alternative is that you're not able to provide full access, is that an okay, I guess, resolution of the issue, or is a voluntary, ECL regime where if a library wanted to take advantage of it and pay for full text access under an ECL regime, they could. If they don't, then they obviously would not have that option. So I'm just trying to see kind of in more detail whether the alternative is something the current status is something you're willing to
Well, I think right now we cannot make, and we do not make, full text access available. We would like to be able to do that, but as I said earlier, I think we would want to work with individual rights holders and prioritize categories of content, or books rather, in the Hathi Trust database to try to do that. Individual libraries may have slightly different preferences depending upon the collecting areas that they have and what the curriculum on their university campus is or their community needs. But I would say, in general, the market solution needs to work rather than an imposed solution.
I think I saw Lauri, Jan, and then Ariel.
I have a confession to make. I'm a foreigner too.
Oh, sorry. Yes.
And not only that, but I actually am Finnish.
Oh, wow. Well, tell us about the Finnish ECL procedure.
I won't go into details. Just following up on your question and a couple of sort of more technical points. I think it is a really big if you would consider an ECL in this country, drawing up from the Nordic and European and international experiences, I would say that you would need to go through the type of sort of exercise that you were outlining, which is consider sector, consider the uses, look at the representativeness of the body that would seek to become an ECL licensing body, and ensure opt-out. Mm-hmm. And maybe those are the sort of the ingredients that you could come up with. But having said that, we have already a couple of examples where actually ECL has been the follow-up on a sort of an industry agreement. What you were referring to, the MOU, the European MOU, and what happened in Germany. Actually, broadcasters' archives, or there's a similar process in the Nordic countries where actually the industry first negotiated, and then ECL was enacted after to support the industry agreement between all the stakeholders. Maybe in those circumstances, ECL could be something that works. But then it really, I think, it has to be narrowly construed. You need to have the safeguards, and it has to be supported by all the participants.
Thank you. Ariel and then Jan, and I think then we'll close it off, and have audience questions or participation.
Okay, so just about the idea of narrowing down to books and, let's say, libraries and educational institutions or something like that. Okay, so I want to make two shocking revelations and one trivial economic observation. So the two shocking revelations are the following. First, the resources and budgets of libraries or universities and so on are finite, right? They're limited and they're finite. There's only that much amount of money that they have in any given period. Revelation number one. Revelation number two, you can only digitize, reuse, or whatever you do with what you actually have, right? With your actual collections. Now, if doing more things with what you actually have costs more money because you need to get licenses for reusing those things that you already have, and you need to get it from a monopoly, then trivial economic point number one, if price go down and you have limited resources, you have less money to spend on other things. And that means for libraries, again, the more it costs them to reuse their existing materials, the less money they have to spend on new acquisitions of new books. Why is that in the interest of known owners, known authors, and libraries? I don't know. I don't think it is.
Jan, and then I'll actually let Brandon and Yorker follow up with really very, very short comments as we're getting ready for the audience.
It seems to me that a library who purports to want to give universal access to its collection and has a digital copy available to it, then it should want to be able to do that in a perfect world. Let's say money is not an object. Here it is an object because they're not able to do that because fair use doesn't allow them to do that. So if a library wants to find a rights holder, and apparently Mike may have a way of doing that, it would seem that a registry of rights holders who would step forward and say, here is my book, I'm ready to have the following uses for it. If anyone comes to you and agrees to that, then that's fine. They can use my entire book digitally and make it available for everybody in the world. And I just want to comment, we have a registry that the Authors Guild, the Dramatists Guild, the ASJA, and the Agents Organization developed in 1995, and we've paid out $20 million to date. We've paid over 10,000 authors, members and non-members, and last year we distributed about $2.8 million, and the principal people that we get money from are the Authors Licensing and Collecting Society under an extended collective license, and LIRA in the Netherlands for library lending right payments. And we have 1.25 employees that are doing this, and we're very successful. And we did a sampling, and our success rate is better than 80% in finding people whose names are given to us from these agencies as being owed money from foreign rights organizations. So I think it would be more efficient and probably relatively inexpensive if you could set up a registry that would be able to find people efficiently, quickly, and allow much more than the Hathi Trust case allows now.
Thank you. Ariel, and then really briefly Yorker, and then we have a few minutes before the Brandon, and then we have a few minutes before we'll have like a few minutes for audience questions. So Brandon and then Yorker.
So I just wanted to point out that there's a really nice way that the fair use and faired use dynamics can work together here. And that is that if you agree with Professor Carroll, and I do, that and with the district courts so far, that there are some kinds of uses that are mass digitization uses that are fair. then you get all this stuff into the digital format that would not otherwise be. And you have people, do-gooders like Hathi Trust and, craven monopolists, or however you'd like to characterize them, like Google. They're digitizing for their own reasons, right? And they're climbing this mountain of challenges in terms of getting stuff into the digital, right? And discoverable and seeable. So fair use gets you that far and no further, right? So the uses that are contemplated short of the Google Books settlement are actually pretty modest. Again, nobody except for the print disabled, who, if anybody deserves it, they do, gets full access to this corpus. And then if you want to do more, then you got to go and find somebody or hope that they find you. And increasingly they know who you are because they're suing you. So there's a nice push-pull going on here. That is, stuff that wouldn't otherwise get digitized gets digitized for good reasons that hurt no one. And then for the further reasons that make people nervous, you go out and get a license. I think that's actually not a terrible dynamic, and that's the dynamic we have right now.
Yeah, and I would just follow up on the question. I think one of the questions we're asking, though, do we have an effective regime that allows you to go out and get that license if you're wanting to, for example, digitize and make available an entire collection where some of those owners may or may not be locatable? Jurka, and then we'll open it up for a few minutes of audience comments.
There's a consortium in Europe called eBook on Demand. It's situated in Innsbruck. It's 35 libraries, national libraries, research libraries. They try to clear rights. Sometimes take up to 6 months, and they still conclude they couldn't clear rights. The total of those collections would amount to quite many books. We have just, as far as funding, I mean, funding is never reason to violate copyright or any other legislation, so there's nothing such a free lunch, I'm told. But if you don't have the money, you might find reason to have a public-private partnership. We've had with one publishing house, Schibsted, digitized some 3 million newspaper pages. The ECL is we need that to digitize and make available to the send the files to the publishing house, and we're about to negotiate an agreement with another publishing house, almost the same amount of newspaper pages. And I calculated the first agreement that would amount to some 30 million copyright protected works. I can't imagine anyone who would have the staff to manually clear the rights of those works. Articles goes way, way back. But if anyone could find a way, they would please find the model. But as I see it, it's collective licensing you could resort to, because the transaction costs going about that would be so high it would never happen.
Thank you. And now we'll open it up. We only have a few minutes. We'll open it up for a few audience questions. Gene?
So my comments are directed specifically related to collective licensing, photo space, not archiving or preservation use. And I guess in the best of all worlds, I would say our members would prefer to have a rights-managed, licensed usage for their images. But I guess I would say that in the photo space specifically, there is a market failure right now. And that in the secondary rights, so the secondary licensing of images, I would say that the vast majority of those images right now, that those needs are being fulfilled by theft of images, theft of service. And there are any number of business models that are built on the display and transmission of images without any compensation going back to rights holders. And that perhaps some form of collective licensing would be a solution for those secondary uses.
Thank you. Carrie?
Hi. Following up on points the others made, a quick introduction and points. Addressing foreigners, I'm a former member of the NUJ. I've covered news in the UK, Ireland, and parts of Asia Plus. Addressing point one is authors' contracts allow the publisher to produce the book in alternative formats. You have to pay the author and the illustrator their contracted royalties. It should not be for free. Two, there's a lot of chuckling going on about museums and artifacts. Let me make the point that there's a continuing and growing effort by countries to repatriate their icons and artifacts that are in museum collections. Case in point, Monument Men with George Clooney. Three, respecting entities that set up models and now don't want to pay the royalties due. You sort of put the cart before the horse, knowing all along that the works belong to others. And four, to whomever had said if you have less money by paying content owners their royalties, it's not the concern of the content owner, because in not paying royalties to the content owner, they have less money too. So thank you.
Thank you.
This has been a presentation of the Library of Congress. Visit us at loc.gov.